Go to the Commission of Inquiry into the Joburg building fire, which is currently handing down its judgment on the application that has been brought for the recusal of one of the commissioners, Advocate Thulane Makhubela. Let's now listen in.
Inquiry because he has a xenophobic mindset. Ms. Mapule Ndaba is a long-standing resident of Usindiso building. She details an incident in 2023 where Operation Dudula attacked residents of the building. She says that Operation Dudula had, on the morning of the fire, arrived at about 6 a.m. and threatened the residents and sang in praise of the fire. She says that members of Operation Dudula told them that they had warned residents about remaining in the building. The allegations that members of Operation Dudula sang songs to celebrate the fire are supported by a media report from News 24. An extract of the article is as follows, and I quote, "As dawn broke, those who survived sat down with no hope, some missing family members, while others dealt with having watched their loved ones die. Broken, they were forced to move to the end of the street as the scene was taped off. As they stood watching in grief at what had become a recovery mission, members of Operation Dudula arrived. The vigilante organization danced as they sang that they did not care about foreigners," close quotation. The papers refer to Operation Dudula as a registered association whose stated objective is to expel foreign nationals from South Africa. Since its creation, it has been responsible for sustained unlawful activity targeting foreign nationals, including hate speech on social media, evictions from home, barring people from hospitals and clinics. The papers filed by the residents, represented by Norton Rose attorneys, also paint a picture of harassment and assault by members of Operation Dudula prior to the fire. The facts relied upon in this application are undisputed and are therefore accepted as correct. Grounds relied upon for bias. The applicants contend that Commissioner Makhubela might be biased because he has deeply entrenched views about the role played by foreign nationals, both illegal and legal, in South Africa and in Johannesburg. He regards foreign nationals to be engaged in criminal activity, that they should not reside in Johannesburg, and that they have taken over parts of South Africa such as Hillbrow. They submit that the views held by Commissioner Makhubela concern the role of law clinics such as SERI, whose clients include foreign nationals that reside in buildings which are situated in the inner city. They contend that his views concern the activities of entities such as the Inner City Federation that works with communities in approximately 40 buildings in the city. They further contend that his views are averse to foreign nationals and law clinics such as SERI, who are staffed by human rights lawyers. They further contend that since Operation Dudula and Put South Africa First have advocated for and carried out unlawful conduct towards foreign nationals and South Africans living with them, Commissioner Makhubela's support for an association with Operation Dudula creates a reasonable apprehension that he might be biased. They argue that apprehension is that of a reasonable person in the position of the persons affected. A reasonable person in the position of the applicants and the residents of Usindiso, having regard to Commissioner Makhubela's post, like post and reposted post, would conclude that Commissioner Makhubela might be biased in that Commissioner Makhubela is a vocal supporter of and otherwise associated with Operation Dudula and Put South Africa First. The residents of Usindiso have also been assaulted and victimized by members and supporters of Operation Dudula, and its staff has also been victimized by members and supporters of Operation Dudula. Both counsel for the applicants and the surviving residents submitted that Commissioner Makhubela's sustained support for and association with Operation Dudula creates a reasonable apprehension of bias because the Commission's mandate relate to the conduct, rights, and interest of the residents of the Usindiso building, including foreign nationals. Evaluation. There is no ambiguity in the language of the tweets and the fact that they are associated with Operation Dudula and its purpose. I am of the view that Commissioner Makhubela will not be able to adjudicate the work of the Commission fairly and impartially, as he has openly disseminated anti-foreign rhetoric in support of Operation Dudula and put South Africa first. As the residents of Usindiso building state, Operation Dudula is a focused niche group of persons sharing sincerely held strong views about the perceived slights and suffering of South Africans at the hands of foreign nationals. The use of social media to rally and garner support is a tool that Operation Dudula is known by. In June 2029, Nhlanhla Lux founded Operation Dudula. It has, since its establishment, been responsible for attacks and intimidation of foreign nationals within the country in the form of raids and violence. It has a highly active presence on social media aimed at mobilizing members to respond to calls for action. Operation Dudula and Put South Africa First have meted out violence on the residents and foreign nationals of the Usindiso building and have made threats of violence, including sexual assaults, towards service staff. The terms of reference of the Commission include inquiring into the circumstances relating to the cause of the fire at the Usindiso building. Such circumstances will include the role ineluctably played by various stakeholders, such as the residents, some of whom are foreign nationals. Whatever role the residents are eventually found to have played will inform the Commission's findings. In this regard, it is clear that the mandate of the Commission includes the collection of evidence from the residents who are both South African citizens and foreign nationals as to who caused the fire and who must be responsible for that fire. It is noteworthy that Commissioner Makhubela has for the past 6 years on social media expressed a firm view conveying enmity and antipathy towards foreign nationals in general and their undesirability in the city and the country. He also evinces support of Operation Dudula since the latter espouses xenophobic rhetoric. It is indeed so that Commissioner Makhubela holds a firm view that foreign nationals are responsible for societal ills besetting the country, including rampant crime and unemployment. There is therefore a real apprehension that Commissioner Makhubela will be unable to be impartial to issues where they pertain to foreign nationals due to his publicly expressed views about Operation Dudula and its xenophobic cause. On this score, I am therefore satisfied that Commissioner Makhubela will not bring an impartial mind to bear on the work of the Commission, and that is a mind open to persuasion by evidence and submissions of counsel. A closer examination of the evidence of the surviving residents of Usindiso building perspicuously indicates that the fire is suspected of having been started by members of Operation Dudula. This evidence is very significant because the terms of reference of the Commission require it to inquire into the circumstances of the fire at the Usindiso building. This potentially implicates Operation Dudula in the fire. That being so, there is a real apprehension that Commissioner Makhubela will be unable to be impartial to issues where they pertain to foreign nationals and Operation Dudula due to his publicly expressed views about Operation Dudula. On deeper reflection, the distinction between the matters that the Commission is engaged with in Part A of the terms of reference and those in Part B may prove in this application to be one without a difference. The so-called hijacked buildings may very well be occupied by foreign nationals as well. So by parity of reasoning, there is a self-evident confluence between issues in Part A and Part B of the terms of reference. It was considered in argument that certain allegations in the affidavit of Mr. Muyiza were mistaken. That might be so. The overwhelming evidence of the reasonable apprehension of bias by many foreign nationals regarding Commissioner Makhubela, which he deemed unnecessary to rebut, remain compelling. Furthermore, the terms of reference require the Commission to determine who should be held responsible for the death and injuries of those affected by the fire at the Usindiso building. It is common cause that a significant number of people affected by the fire at Usindiso building were foreign nationals. In my view, Commissioner Makhubela's sustained support for and association with Operation Dudula, a group which is founded on xenophobic rhetoric, will not bring an impartial mind to bear on the adjudication of the issues before the Commission. Moreover, Commissioner Makhubela is not a judge, and consideration which apply in favor of an assumption of impartiality for a judge cannot apply to him. It cannot be assumed that he can abuse his mind of any irrelevant personal beliefs or predispositions, as he has taken no oath of office as judges do to administer justice without fear or favor. Irregular application. There was an issue raised by Commissioner Makhubela during the hearing that this application was irregular because the applicant's attorneys met with the chairperson and discussed the contents of the application prior to the lodging of the application. As the applicant's counsel was at pains to point out that there is simply no evidence that the applicant's attorneys met with the chairperson to discuss the actual contents of the application. Counsel pointed out that the applicant's attorneys met with the chairperson to apprise her of the letter they intended to deliver to the Commission, in which an application for Commissioner Makhubela's recusals was foreshadowed. The chairperson, having been apprised of the intention to deliver the letter, gave an indication that she would await the delivery of the letter. Indeed, a letter was delivered to the Commission shortly after that meeting. The suggestion by Commissioner Makhubela that the application is rendered irregular by reason of the meeting that the legal representatives of SERI had with the chairperson prior to the lodging of this recusal application is without merit for the following reasons. First, there is nothing irregular in the legal representatives of SERI meeting with the chairperson of the Commission of the Inquiry to, out of courtesy, apprise her of a letter they intended to deliver foreshadowing the issues that would be dealt with in the application for recusal. Second, the suggestion that the discussion with the chairperson entailed the discussion of the full details of the application is unsupported by any facts on the part of Commissioner Makhubela. And I quote Advocate Makhubela, I quote the transcripts, Advocate Makhubela, yeah, but foreshadowing is one thing. Discussing the contents of the application you bring you intend to bring is another, close quotation. Third, the rules of the Commission make no provision for dealing with matters preceding the lodging of the application. Fourth, had it been Commissioner Makhubela's case to raise the irregularity of the application, he should have responded to the directives which I issued instead of raising it in argument. This he did not do. In any event, there is nothing irregular about the application as it was properly issued in terms of Rule 11. It is instructive that Commissioner Makhubela, in the most egregious and gratuitous manner, hurled insults at the chairperson and the legal representatives of SERI, imputing impropriety and unethical conduct on their part. In no less than 28 number of occasions, Commissioner Makhubela put to the legal practitioners in the application matters which suggested untoward behavior on the part of the chairperson and the legal representatives of SERI. The questions were ad hominem and had this totality to them. I quote the transcript, Advocate Makhubela. Now, Mr. Brickhill, here is a matter that I would like you to assist me with. Would it then be reasonable for the person against whom this likely application is brought to then assume, and I just want us to agree on principles, to then assume that the discussions might have gone beyond what we are told? Would it not be reasonable? Is it unreasonable? Close quotation. No supporting facts were placed in support of those accusations, and no legal basis was offered to justify the attack. Failure to comply with Rule 11.4 of the Rules of the Commission. Commissioner Makhubela also raised the issue that the application was irregular in that it did not cite Operation Dudula as a party to these proceedings, even though the applicants allege that Operation Dudula is suspected of having started the fire. It is sufficient to say that when the applicants lodged the application, they did not rely on the fact that members of Operation Dudula were suspected of having started the fire. It is the residents of Usindiso building who, in their support for the relief sought by the applicants, alleged that they suspected that members of Operation Dudula had started the fire. In any event, there is no need to cite Operation Dudula, as it has no direct or substantial interest in the relief sought, which is a recusal of Commissioner Makhubela. Indeed, they may have an interest in due course of the proceedings of the Commission, and the rules of the Commission provides for procedures to be followed with regard to implicated parties. The role of the evidence leader in this application for recusal. Commissioner Makhubela further questioned the role of the evidence leader in this application. It is again sufficient here to state that the role of the evidence leader in the Commission is set out in Clause 3 of Part A of the Terms of Reference, and I quote, "The Commission may choose and appoint one advocate who is a registered member of the Legal Practice Council of South Africa to act as counsel to the Commission, to assist in the inquiry, advise on matters of law and evidence, and present evidence to the Commission at its inquiry," close quotation. It is also important to highlight the provisions of Rule 11.5, which states that, and I quote, "As soon as possible after the chairperson has become aware of such an application, she must issue such direction or order as to the future conduct of the matter as she may consider appropriate." In line with this authority, and as soon as the application had been lodged, I caused to be issued directives on 31 October 2023, calling on the evidence leader to file its heads of argument in the recusal application. On 16 November 2023, I issued directives calling on the evidence leader to deliver its supplementary submissions on the issue of the decision-making process. On 16 November 2023, I issued directives calling on the parties to deliver supplementary submissions on the decision-making process regarding the recusal application. The terms of reference, the Provincial Commissions Act, and the rules of the Commission do not provide for the decision-making process for a recusal application. There are, however, significant indications that the chairperson of the Commission is ultimately the only commissioner to make the decision in a recusal application. The rules provide for certain decisions to be taken by the Commission as a whole and others to be decided by the chairperson alone. The decision to be taken by the chairperson alone relate to legal issues and to the procedure and the conduct of the Commission. The rules governing the proceedings of the Commission and published on 17 October 2023 in terms of General Notice 1193 of 2023 provides in relevant part, and I quote, General, 1. Any party wishing to make any application to the Commission which is not otherwise provided for in these rules must do so at least 7-day calendar notice in writing to the Commission, but the chairperson may condone non-compliance with this notice period on good cause shown. 2. The Commission may condone non-compliance with or extend any time frame provided for in these rules on good cause shown when it is in the interest of the work of the Commission to do so. 3. Wherever these rules make provision for any person to apply to the Commission or to the chairperson, the application must be a substantive application on affidavit with a notice of motion. The affidavit must, among other things, reflect the relevant facts, the order sought, and the grounds relied upon to seek that order. 4. The application must be lodged with the Secretary of the Commission, who will ensure that such application is delivered to the chairperson and to the evidence leader. The applicant in that application must cite every other person whose rights may be adversely affected by the order sought and serve a copy on him or her or it. As soon as possible, after the chairperson has become aware of such application, she must issue such direction or order as to the future conduct of the matter as she may consider appropriate, close quotation. The roles and powers of the Commission are spelled out in the terms of reference as follows. I quote, whereas Section 2(1) of the Provincial Commissions Act 1997, read with Section 127, 2E of the Constitution of the Republic of South Africa 1996, gives me the power by proclamation in the Government Gazette to appoint a commission of inquiry.
Well, that is the judgment being handed down by Justice Sisi Kampepe, who is the chair of the Commission of Inquiry into the Usindiso building fire. And the recusal application has been brought against Advocate Thulane Makhubela. And looking at the initial remarks there by the Justice, it seems as though that she will forge ahead with the recusal of Thulane Makhubela because of the apprehension that he could not be impartial, considering, of course, his support for Operation Dudula. So we'll bring you more analysis.